ready on that matter?
Yes, sir, right now. Before we begin the sentencing, the department has asked that I raise two objections on his behalf. Two proceedings. One being that he objects to being sentenced to any jail time as a result of being denied the right to counsel under Parsons versus Hamlin, which states that if you are denied the right to counsel, that it's inappropriate to sentence to jail time under such circumstances. The second objection, Your Honor, is one that I believe he's made already, that he had asked Your Honor to recuse himself earlier, and he just wanted to make sure that that was a part of the record that he had made that request.
Now, Mr. Parsons is represented by Mr. Whittington, now the fourth attorney, I think. Now, the public defender had a conflict with the other attorneys, Mr. Robbins and Ms. Neal, who the Honor is well familiar, and we've been through this on numerous occasions, try to best to represent Mr. Parsons. And had he listened to him, I think it's probably going to be in the orange jumpsuit that we're in today. So he's had attorneys, he just had to listen to him. So I think that's not well founded.
The court's addressed both of those issues already. And to address them again, if need be, but today is the sentencing hearing. Mr. Parsons' reason for recusal is shortly before
trial date, the day before trial date, he filed a civil lawsuit naming a number of people involved in the judicial process, and I guess that takes the opinion that he can sue civilly people involved and therefore can no longer be prosecuted. And, the court didn't feel like there was a reason for recusal and still doesn't. And the defendant has had attorneys appointed. Are you representing him today?
Yes, sir.
All right, you ready to proceed? The defendant was convicted by a jury of 3 felony offenses and 2 misdemeanor offenses. The state has filed a Board of Probation and Parole investigation report. Have you been over that with your client?
Yes, sir, I have. And there are 2 corrections, relatively minor in the grand scheme of things, but they are corrections nonetheless. One is has to do with his educational background. Your Honor, he does make a notation. He has a degree in mechanical engineering. It said that independent verification was not requested due to his age, but he did want that as a part of his recent report that he does have a degree in mechanical engineering. And one additional, Your Honor, under military information, he was reported that he does indicate he was part of the Civil Air Patrol from 1919 to 1994, and it states in here that he reports no military history. He's indicated that that is in fact military. So that's the only correction. Otherwise, we stipulate to his accuracy.
The court then will accept the pre-sentence report by stipulation unless the state wants to put on the officer.
No, sir, I don't even know that there's any disagreement, other than I assumed that civil meant not military. But I'm just not worth quibbling about.
He indicated that he had military ID and federal functions on it. But that's what he meant.
court then accepts the report agreement. Included in the report is a victim impact statement, which the court's read, and a statement by the defendant, which the court's read. And state, have any other witnesses?
Mr. King or Mr. Laxton here, or anybody wishes to be heard. Now, I will rely on the victim impact statements as they're included in the investigation report and on the facts that came out of the trial.
Yeah, if I could begin by introducing two exhibits. One is a set of letters. If I could make this a collection exhibit.
Yes.
The other exhibit, Your Honor, would be his diversion eligibility certificate from Tennessee Bureau of Investigation. I believe now has been marked as one is a set of letters that Mr. Parsons collected various members of the community and on his behalf, and particularly pointing out placed at the top the letter of Mr. Hess, retired Navy officer. And Your Honor, I also a motion to grant judicial conversion with the memorandum of support, and that of course is what we are requesting of the court today. In terms of proof, I'd like to put on Mr. Parsons' motion.
So I swear or affirm testimony given this college
I've just been handed one additional letter. I apologize to the court. If we could make this a part of Exhibit 1, it's one additional letter from my close friend. Ms. Bernie Cupid.
You're gonna let me fall down. That's big too. Don't put me outside.
Thank you, Your Honor. Can you state your name?
Michael Parsons, and I've left my glasses over on the desk. Sorry.
And how old are you, Mr. Parsons?
48.
And where do you reside?
Hughes Road, Brighton, Tennessee.
Okay, you live on, is it a farm?
It's farmland. We have a house, and we do hay farming.
You have some acreage there, is that correct?
Yes.
And if we could go through some of your social history, what do you do for a living?
I do a lot. I have a business as a professional home inspector. I'm a consultant. I do work for the public inspecting homes, commercial buildings. I act as expert witness from time to time in the court system, advising litigants regarding the condition of homes, if contractors did the job, if they didn't do the job. I'm also a licensed general contractor, more of a consulting, paper pushing as opposed to actually driving nails type of job. Again, the hay farming business. And up until recently, for the last year, I was a radio talk show host out of a station in Millington, Tennessee, doing a ministry of sorts for the public.
Okay, what are your hobbies and interests? I know you mentioned the radio show.
Most of my time is spent with my animals. I've spent the last 30 some odd years raising wolf hybrids, dealing with wolves, working with zoos. I worked with a relocation effort back in '95 to bring wolves from Canada to Yellowstone. I was somewhat instrumental in getting the program out at the zoo, the Teton Trek, to include the wolves. Former relations with the former curator at the zoo who used to buy hay from us, and he would come out and enjoy seeing my wolf hybrids, and would go in and play with them, and so he knew their nature. And I've spent an abundance of my life trying to dispel the lies and the myths about the villain, the wolf. And in fact, there's never been a case in American history or Canadian history where a wild wolf has ever killed a human, but yet people are believed to fear an animal which has never harmed anybody.
So it's fair to say then that you have a special connection with wolves.
Well, I do, and it's more than just an interest. Being 3/4 Cherokee and doing my genealogy, finding out that I'm actually descended from the Wolf Clan. And the Cherokee Nation had 7 clans, and the Wolf Clan was known for their, well, they domesticated wolves. They used them for all sorts of things, but that was part of my genetics, I guess. So,
I understand. Are you married?
I am.
What's your educational background?
I have a degree in mechanical engineering.
Okay, and where'd you get your degree from?
It's now called Southwest, so changed names.
And when did you obtain your degree?
1988.
As far as your criminal record, as I understand it, we submitted to the court, you have no criminal record before this incident. Is that correct?
That's correct.
As far as your physical and mental health, are you in good physical and mental health?
Excellent. Other than being gassed the other day in the cell for about 3 hours, I'm okay.
You ever been diagnosed with any serious physical or mental conditions?
Never.
Going to the circumstances of this offense, would you agree that this incident occurred under unusual circumstances?
Very unusual circumstances.
Would you agree that at least one of the things giving rise, I know there were many factors involved, but at least one of the things giving rise to this incident was the fact that your wolf got out of the enclosure?
Well, Brandy is a wolf hybrid, and she did get out of the backyard. Apparently, while I was away, she raised the latch on the gate and got out. At that time, as I understand it, there were several stray dogs running in the area, and apparently she saw fit to go play with them. And when I got home, Pat called me, went looking for them, and heard gunshots, which were in a kind of a rural, even though within a square mile there's about 82 homes. A lot of homes, but relatively speaking, most people have 5 to 30 acres or so. So it's not uncommon for people to target practice. And went looking for Brandy, and my wife was at the front of the property, and I had crossed over the fence to investigate, and witnessed a person who I didn't know who it was at the time, which later was identified as Barry Laxton, shooting in the direction of where my dog was, but just beyond my dog was my wife standing in the wooded part of our field. We have, the front of our property is wooded, a lot of pine trees.
So were you out there to recover your dog?
Yes.
And would you agree, though, with my original question, that at least one of the factors that gave rise to this incident that was necessary in order for this incident to occur was the fact that your dog got out?
That's correct.
And as I understand it, you have taken steps to construct a secondary fence, or at least lay the groundwork for that. Is that correct?
That's correct. I've purchased a substantial amount of fencing material to basically enclose the backyard, so that if somehow they climb out, dig out, or get out, there's going to be another fence of about 7 foot tall that will, prevent them from going any further.
As I understand, it's kind of an extraordinary fence of superior quality. Is that fair to say?
It's not chain link. It's not your backyard fence. It's cattle panel, which is about the thickness of this pencil, very thick gauge material, suitable for cattle, and large enough that it will keep our pets in if they happen to get out of the chain link fence, which is what we've got now, which is pretty common for most people's yards, is chain link fencing.
Okay, now I know you can't make a guarantee, but in your opinion as an animal keeper, will this secondary fence be sufficient to prevent your dogs from getting out again in the future?
I believe it will.
Will you make every effort when you are eventually released, will you make every effort to make sure that the dogs don't get out of your enclosures?
Yes, I will.
And you've also indicated that you were going to take some steps to educate your neighbors about the dogs, and what will you be accomplishing by doing this?
Well, during the trial, I was impressed by one of the ladies who was the mother of a man who lives in the community, who I really don't know that well, but he had shown hostility in the past towards us for no apparent reason other than he didn't know us. Maybe rumors, who knows? We've only been in the county for, what, 12 years now, so we're relatively new, as most people perceive. If you weren't born here, you're not from here, you're not really welcome. But she expressed an interest to communicate with us, and that she's sorry that this thing gone so far. And she really wasn't worried about our dogs. I think the impression was that they're more hostile towards me for no known reason, but there seemed to be an interest in building a bridge there. And so what I would try to do, as when our next door neighbors were, Brandy was shot and killed, when they moved there, the previous neighbors, they came over and played with our dogs.
Is it a fair summary of what you're saying?
So we've made an effort in the past. So certain neighbors have met our dogs and know about our dogs, but certain ones haven't, just because we haven't had the opportunity. But it seems like there apparently is now an interest in bridging that void, and I'll take every opportunity, as much as people are interested, to expose my animals to them so that they know that these are not aggressive animals, if that's a concern, and let them know that we are genuinely good people. Despite having run for political office doesn't necessarily, in my opinion, make you a bad person. I ran for issues, not against people.
Getting directly to the mitigating factors that we've mentioned in your memorandum in this case, do you feel that you acted under strong provocation during that incident on September 24, 2007?
I would say witnessing my dog being shot and killed right in front of me, her dying at my feet, my wife being shot at, and bullets flying past my head, I would certainly say that's extremely strong provocation.
Although you failed at least at trial to establish in the eyes of the jury an affirmative defense of self-defense, and also that you were effectively affecting a citizen's arrest, do you feel that grounds under the circumstances existed tending to justify or excuse your actions?
I did everything that I knew to do according to the law to protect myself, to enact a citizen's arrest, which is lawful. Citizen's arrest has been on the books forever. The ability for one to defend himself, the fact that you're not required to retreat. I am a licensed permit carrier since 19 years ago, when I was issued a special permit through the Shelby County Sheriff's Department because of my work with the government as a pilot. Never had to use a gun, never did use a gun in this case, as a matter of fact, but the jury chose not to, I guess, listen to what I was saying, or whatever the case may be. The situation was that had he not crossed the street off his property and shot 29 times at my family, I wouldn't have been there.
Yes, sir, I understand. Now, this is similar to the provocation question, but also another statutory factor. Do you feel that you were acting, that you were under stress or duress at the time of the incident?
I would say that certainly I was under stress, but I would say that my actions were reasonable and restrained. So many people I've spoken to said that if somebody's shooting at them, they're going to shoot back. And it's like I tried to explain that if you weren't there, you really don't know. And the fact that the distance between us was such that shooting back at him while he's shooting at me, yes, I might have hit him, but I might have missed and jeopardized people behind him if in fact there were people in the house behind him. My interest was to stop the threat against my family, not to harm anyone, to preserve everyone's life, and that's my
I understand
goal.
that you considered your response to the situation to be controlled and a rational response. So would you agree, or is it true at least that it was also an emotional and stressful situation?
Certainly.
Did you assist the authorities in uncovering any of the property involved in the incident?
As a matter of fact, I confiscated the rifle that the shooter had used to shoot my family, which was laid in the back of a truck. He had concealed it immediately after the shooting and would not reveal its location when I'd asked him multiple times. When I saw it, I confiscated it, as well as a paddle holster, which I knew would be able to show the officers, in fact, that both men had been armed in case they tried to deny it. I would have the proof, physical proof, to show them both men were armed. And when the deputies arrived, immediately I presented them with the rifle and the holster and advised them of the crimes, the felonies that I had witnessed, which would have been the basis for the citizen's arrest.
As far as their investigation of you, though, did you cooperate fully in their investigation of you?
Oh, certainly.
Did you turn over anything that you had that
Yes.
they were interested in?
Yes, immediately gave them the pistol that I had so that they would know that there's no danger to anybody.
Would you say that you're genuinely sorry that this incident occurred?
Certainly.
Can you assure the court that you will do everything within your power to make sure that these sort of circumstances don't arise again in the future?
Immediately, we're going to have the fence put up. I'll be working to finish the fence that I'd already started. We've got the material. And we're looking at other things, such as possibly moving from the area, because apparently if the threat to my family is so great that people are willing to cross the street and shoot at us and they're not held accountable, then this is no place to live.
If the court sees fit to grant you a diversion, would you be willing and able to comply with any of the reasonable terms of that probation or whatever they may be?
I think reasonable terms is the key word.
Well, ordinary terms of probation, such as submitting to supervision if necessary and reporting to a probation officer on a monthly basis for whatever period
That's required, certainly. I'm not going anywhere unless we're able to move, and then I would ask to be allowed to transfer probation if that be the procedure.
Okay. All right.
I'm familiar with all the procedures, so
Do you have plans on relocating soon?
well, that's, this economy, it's very tough to buy or sell property, and that's a situation we'll have to try to look at very closely and see what, if anything, can be done.
But for today's purposes, you're asking the judge to grant you diversion and allow you to return home to your work?
Yes.
To answer any of Mr. Previous questions.
Three-quarter Cherokee,
Correct.
so you, one parent is full Cherokee, and the other is
Excuse me?
half Cherokee. That's what you're saying?
Not at all.
I'm sorry, so what do you mean by three-quarter Cherokee?
That's a percentage.
I understand. Would not one parent have to be full-blooded Cherokee?
Not at all.
One parent have to be half Cherokee?
Both parents.
Three-quarter?
No, sir. Both parents could be three-quarter Cherokee. One could be a various percentage. You just add the two numbers and divide by 2, and you get the ratio.
Tell me, this really has nothing to do with anything other than your perception of reality. One parent was what percentage? Cherokee.
If you turn around and look behind you, you'll see my mother, who's Cherokee, and you'll see my father, who's Cherokee.
Your
They're right
father,
behind you.
as far as you understand, your father is what percentage Cherokee?
In doing the genealogy study, my father is full-blooded Cherokee.
Well, that's what I asked you. So one parent
But
is
the
full-blooded
ratio-
Cherokee.
But the assumption is that the ratios come from one being one being the other. But the reality is that they can come from various degrees. There may be somewhere in the history of my mother where there's more Cherokee or less. To the degree that we've been able to establish, this is the percentage that we have.
Mr. Parsons, bottom line is, you don't see reality as the rest of the world sees reality, do you? Because 3/4 means 1 plus a half divided by 2 is 3/4. You argue even with that.
Or 3/4 and 3/4 equals 3/4.
6/4. You were asked about your mental health, and your opinion is you enjoy good mental health.
That's a fact.
Weren't you examined in connection with this trial regarding your mental health?
The evaluation was at the direction of one court-appointed attorney who had, well, in fact, assaulted me and didn't want to be on the case at all. Hers was a retaliation, and ultimately the evaluation came back that there was no reason why I couldn't. The evaluation was to determine if I could assist in my own defense, and the nature of what happened at the scene. And the response of the doctor who did the full evaluation, Dr. Sayoka, was that I acted rational, responsible, and that there's no reason that I couldn't assist in my own defense. And he was quite curious as to why I was ever even sent to have the evaluation, because normally people that present themselves, as he said in my case, aren't evaluated. It's normally people who truly need assistance from
Mr. Parsons.
that standpoint.
If I could object. Excuse me.
Object to Mr. Parsons?
Object to further questioning on his line that I didn't have the benefit, Your Honor, of being his attorney at the trial level, and in my earlier discussions with Mr. Parsons, as I understood it, the psychological report, one or another of them, was excluded from the record. So if we're discussing a report that was excluded from the record, I object on that basis that it not come in.
They're both in the record. Mr. Parsons filed a motion to have one excluded. The motion was denied.
Thank you.
Mr. Parsons, in getting back to my observation to you that you don't see reality as others do, I asked you a question which called for a yes or no answer. So there was an evaluation. In fact, there were 2 evaluations done, mental evaluations done of you, correct?
That's not correct.
There were not 2 evaluations done of you?
There were no 2 evaluations. There was one full evaluation. There was another attempted evaluation where the officer could not locate the building, and which was subsequently the reason why I was arrested the first time, because I was not able to make an appointment, which the address given to me was the wrong address. I was not provided a phone number, and when I missed the appointment, I was arrested, and then even the officer who took me to the appointment couldn't find it. We were late, thereby the doctor only had about 30 minutes to do an evaluation. It would have taken 2 hours, and in his own notes he said it was an incomplete evaluation. But as you understand, I like to give long, detailed explanations, and in his evaluation he tried to claim that I gave short answers, which anybody that knows me knows that's not the case.
Well, then, there were 2 evaluations, attempted evaluations, visits to a doctor. You saw 2 people, right?
Seeing 2 people is not the same as having 2 full evaluations.
One evaluation you agreed with and one you didn't.
No, sir, one was not a complete evaluation. It was a recommendation to continue and complete a full evaluation. And it should also
That's Dr. White, correct? The evaluation or recommendation to which you're referring is Dr. White.
And I believe when I made the motion that that be stricken from the record, if I'm not mistaken, it was agreed upon that it would be stricken. That's why it's in seal.
Yes, sir. Mr. Parsons, we didn't proceed with it at trial because it wasn't particularly relevant. But your attorney asked you if you enjoyed good mental health. You said you did. But the fact of the matter is that there have been professionals that have disagreed with that.
Well, that's not true. The record will clearly show that his evaluation was incomplete, and he recommended further evaluation. Once a full evaluation was done, the doctor concluded there's no reason for me not to be able to proceed to trial to assist in my defense, and that my actions were reasoned and responsive to the situation.
So you don't have, obviously, any objection to either of these reports being considered by the judge in your request for probation under diversion or probation?
I would object to Dr. Wyatt simply because Dr. Wyatt, as the professional doctor told me, Dr. Wyatt sees criminally mentally ill patients every day, and I would be an enigma to him. He is not used to interviewing
Mr.
people.
Parsons, you're an enigma to a lot of people, aren't you? Aren't you?
I don't believe so.
Well, let me ask you about the unusual circumstances Mr. Witherington asked you about. The unusual circumstances relating to your the animals getting out. That's not an unusual circumstance at all for you, is it?
We've had our property for 12 years, sir, and 12 years we've only had an animal get out 3 times. When we lived in Memphis for 17 years, we had animals get out twice.
Well,
that is not unreasonable. And as a matter of fact, in the news recently, a person's dog got out in the county a couple of weeks ago. The neighbor turned on the light, shot and killed it, and she wants answers. Apparently, the green light's been given for people to randomly kill people's pets, and nothing will happen. That's a concern of the community.
The question to you, Mr. Parsons, is it an unusual circumstance or not for this situation to develop about your wolf dogs getting out? And how many times have you been prosecuted for wolves, dogs at large, whatever? How many times have you been criminally prosecuted for it? You have never been in General Sessions Court on a charge of your dogs running at large?
That's not a criminal charge, sir. It is
a criminal charge.
No, sir, it is not. No, sir, that's a civil matter. If you look at the statutes, that's civil, and you know that.
Well, Mr. Parsons, I don't know that. But in any event, how many times have you, in your opinion, been civilly prosecuted for dogs running at large? How many times have you been over there in the civil part of General Sessions Court under Judge Peeler with the district attorney or Mr. Duke Brasfield involved in the prosecution for your dogs running at large?
May I answer that question fully, Your Honor, since I was sworn to tell the whole truth?
Well, first of all, if you would answer it fully.
I would like to fully answer that and not be shut off.
How many times?
The fact is that when my dog got out and was shot by a neighbor 4 years ago, I wasn't even there. My wife was there. She was originally charged, and then when I came back to Memphis, or to Tipton County, when I returned home, they dropped the charges against her and charged me because I was the person they wanted to charge. This is political. This is the only place that I know of in this country where they prosecute individuals for a dog getting out of the yard and allow the neighbors to shoot and kill a dog on site.
I thought you said it was civil.
You prosecute civilly as well as criminally, sir.
All right. Well, how many times, to answer the question that I asked you, how many times have you been prosecuted civilly in General Sessions Court of Tipton County for your wolf dogs running at large?
I believe that case was expunged.
Can you answer a question, Mr. Parsons?
One time.
One time?
One time.
All right.
That's the only time in my life.
In the court.
That's the only time in my life I've ever had a complaint against my dogs. And in that case, animal control came on my property and confiscated 3 of my dogs sitting on my porch and claimed that they were running loose, which the statute says the animals have to be off your property. That's why when it came to the circuit court, it was dismissed. The prosecution decided not to prosecute because they knew they didn't have a case. Your prosecutor didn't prosecute because you had no case. The dogs were on my property. Yes.
On a civil case?
Yes.
Do you know the difference in a civil or criminal case, Mr. Parsons?
Yes, I do. This court handles both civil and criminal cases.
And do you know that the state didn't want to prosecute because they didn't want to deal with you any more than they had to, the state of Tennessee, in prosecuting you?
Apparently,
Is that the reason?
No, sir. It's because my dogs were on my property and they didn't have a case. You can't prosecute people for civil penalties when the person didn't violate the statute.
All right, Mr.
There
Parsons,
seems to be a problem in this court.
you say that the only complaint that you have had about your dogs running at large was that one time in General Sessions Court?
You asked me, was that the only time I've been in a courtroom, and that is a fact. In my life, that's the only time I've been in a courtroom.
I'm following up on what you said.
That matter.
You said...
No, you're not. You're twisting what I said. What you asked me was, in fact, was that the only time I was in court? Which
I asked you that, and
the
you
only time I was
responded,
in court.
Mr. Parsons, I asked you that, and you responded that the only complaint that you had about your wolves was that one complaint. That's not true, is
Please
it?
refer to my wolf hybrids as wolf hybrids and not wolves.
It's not true that the only complaint that you've had about your wolves is that one time in General Sessions Court, is it, Mr. Parsons? You've had numerous complaints.
No, sir, that's not true.
Brett C. killed one of your wolves, and you broke his nose in response to it, didn't you?
When he attacked me, I punched him one time. The man attacked me. He shot and killed my dog off his property on someone else's property while I'm out looking for it. Before I told him that I was looking for my dog, he said, "We haven't seen it." Moments later, when I drove away, he saw it and shot and killed it without provocation on someone else's property. And then when the officers arrived, he attacked me, and in defense of myself, I punched him. That's why I wasn't prosecuted for that. As a matter of fact, the grand jury came back with a not true bill because they thought the whole thing was a sham.
Well, Mr. Parsons,
But that
my
didn't-
question to you.
You asked if there was a
My
complaint.
question to you, Mr. Parsons.
I think he's trying to continue answering.
I think he's trying to...
There's never been a complaint. There's never been a lodged complaint in any court in any state in this country or the universe other than the one time where the animal control went on my property without provocation and stole 3 of my dogs, and that was their own complaint. There's no other complaints in the record anywhere.
Okay. Listen to me, Mr. Parsons. You said that there was no complaints. Now you're saying that there are no lodged complaints. But the fact of the matter is, numerous neighbors have complained. Some have taken further actions in killing your wolves to lodge their complaint, haven't they? Haven't they?
There's no lodged complaints. Now, I don't know what you're talking about. If they called you on the phone and told you personally something, that's not a part of the record. There is nothing in the record about any lodged complaints against my animals because my animals have not harmed anyone.
How many of your wolves have been killed by neighbors that have complained by killing them? How many of your wolves have been killed?
You call feloniously killing a person's pet a complaint?
They
Is that what you
complain-
call a complaint? Killing someone's pet?
How many have been killed, Mr. Parsons? They're not a problem, you say. How many of them have been killed not on your
Because-
property?
Because someone kills someone's pet, that's a problem because I had to pull a trigger and kill it off my property. The man went out of his way, crossed the street to kill my dog, shot 29 times, and he went out of his way, so that's his complaint because he broke the law?
Mr. Parsons, how many of your wolves have been killed by your neighbors when they were not on your property?
They weren't on their property either, and it was 3.
All right. In fact, some of them you have sued because of that.
That's fact. That's what you do. You hold people accountable for their crimes.
Is that what you're asking this court to do?
This court doesn't have a civil case before them where I'm suing them in regards to the person killing my dog at this time.
You don't want this court to hold people responsible for the criminal actions that they do?
Defending your family is not a criminal act.
Well, that may be, but the jury said you're guilty. My question is...
A jury
do
who
you
was
want this
employed by the
court-
county who lied under voir dire, one of the jury members was the arresting officer's mother-in-law who has a lawsuit against him at this current time.
line of questioning in the event that, as to his opinion as to how the judicial system should function is not relevant.
I'm trying to determine, Your Honor, his amenability to probation, which he is requesting in diversion and in other probation. Mr. Parsons, you have stated that you believe that people should be responsible for their criminal actions.
Yes, I do.
The jury has found you to be criminally responsible for the aggravated assault on 2 individuals. Now, you will agree that under our system of laws, that your opinion doesn't rule, but the opinion of the jury affirmed by the court controls, don't you?
That's correct.
Because Mr. Witherington asked you if you would agree to, I think Mr. Witherington's words were reasonable terms of probation. And you stated that the determinative factor there would be whether the terms were reasonable.
I've never been provided any terms or anything to that matter, so I can't respond. I don't understand what that term means. Therefore, I was needing to qualify what that means.
Well, it's a pretty simple question. You were asked a simple question. Would you be bound by any reasonable terms of probation? And your immediate response would be that the determinative issue is whether those terms are reasonable. Who determines that, Mr. Parsons? You?
I believe that's for the judge to decide.
So whatever the judge determines to be the reasonable terms, you will agree to, correct?
Certainly, and I would ask that the term reasonable be prudently exercised, because certainly there are, within the court's discretion, things that might be extreme. And in this case, no one was touched other than my dog was shot and killed. This is not a case where I pursued them out of anything other than the defense of my family in the moment where I was imminently in danger at that moment of being killed.
Your idea as to what a reasonable term of probation, Mr. Parsons, is would be just as your determination of what reality is as you've expressed it all through these proceedings, correct?
I'm not sure what your point is.
Well, my point is that everything that you have said happened has been determined not to be the case by juries, and your perception of reality doesn't seem to coincide with at least the majority rule, if that's correct, of what reality is. Would you agree with that?
Not at all. The juror did not find reality. The jury just made an opinion. Regardless of whether they cared that this man shot at us 29 times, which is a fact, it's not a reality beyond the scope of the court's record. In their mind, they may think that that was okay to shoot at someone's dog if you don't feel that you're safe where there's a dog that you don't understand. In the real world, people don't just shoot at people's pets. That's a crime. And in the state of Tennessee, the clear law says that anything less than a full-blooded wolf is a domestic pet, and therefore is regulated as such and has to be treated as such. And my dogs have never harmed anybody, so the reality is, in this case, my dog was shot and killed. My wife was shot at. I was shot at.
And Mr. Witherington asked you about what steps or steps to be taken to educate your neighbors. What do you got in mind about educating everybody and enlightening them on the
Well, I'll make every attempt to speak with the neighbors that they have nothing to fear of me or my dogs. And certainly the lady who expressed interest in that, I would try to contact her immediately and take one of my wolf hybrids over there and let her see him and pet him. And you know, if she's amenable to that, I think she'll learn that they're just like anybody else's pet. They're friendly, not aggressive at all. Great family pets, as a matter of fact. There are dozens of them throughout the county right now.
Mr. Parsons, you're not suggesting that you're going to go door to door trying to educate people and carry your wolf hybrids with you, are you?
I would try to contact the people in this area. Pretty much know each other, and I think if I spoke with her and she had a good understanding of who we are in our hand, certainly I think the phones would ring and she would be talking to her neighbors, because obviously there's a lot of communication amongst the neighbors.
You're not going to go door to door with your wolf hybrids to educate them.
Well, the people across the street already know us and our neighbors. The stewards across the street don't have a problem with their animals.
Well, I'm just trying to figure out what is meant by.
There are several neighbors that know us and like our animals, and it's just about 4 families that don't.
those families that don't know you or don't like you or don't know your wolves or know how wonderful they are you going to take steps to educate those people?
I think the lady will communicate with them. This is the lady who is part of that group of people that have that viewpoint. And she expressed interest in meeting with us and speaking with us. And so we're going to take that opportunity to do that. But I don't know about your suggestion of going door to door.
I'm not, don't say that's my suggestion, Mr. Parsons. It's my question to you.
No,
is
sir,
that your plan?
that was not my intent.
Okay. Now, Mr. Witherington asked you about the fence that's now being constructed, I guess, that will keep it. How many hybrids do you have now?
I haven't been there in 46 days. I have no idea.
Well, how many do you sell? Would it be much different? Do you sell them on a daily or weekly or yearly basis?
No.
Okay.
We normally have, at the most, 1 litter a year, and usually they're pre-sold, and if we have any left over, then we'll run an ad in the paper. But no, we normally have less than, on average in the last 10 years, less than 1 litter a year.
Have you communicated with your wife since you've been in jail?
Yes.
You know exactly how many hybrids you got, don't you?
No, because we had a litter of puppies, and I don't know exactly what she sold and what we had.
Mr. Parsons, can you answer any question straight out? How many hybrids do you have at your house?
I don't know. I'm not there.
Do you know within a range of 50 or 100 how many you got?
I think I've answered that question before. It's about 30.
Well, you finally did, Mr. Parsons. It's about 30.
We covered that before, and with puppies, I don't know. I'm not there.
About 30. That's good enough. So you're building a fence, or a fence is being constructed that you believe will be keep this unusual circumstance of a hybrid escaping. It will keep that from happening again.
I think it will. But it's not against the law for a dog to get out of a house or out of a backyard and run around. That's not crime.
All right. We're trying to address what you called the unusual circumstance of your hybrid getting out. The point is that you were before the General Sessions Court how many years ago was it now that this matter first came up on your hybrids being at large?
6 years ago, I believe.
6 years ago, you were telling Judge Peeler of the efforts you were making to make a fence that would keep these hybrids in. That was obviously some years before these hybrids that were the subject of this criminal action got out.
No, sir, that's not true. What I did is I presented photos. They had requested to see what the fences looked like, and I showed them that apparently someone had opened the gate and let our dogs out, and that we had 6-foot-tall chain link fencing, and that we were going to put locks now on the gate latches so that someone couldn't just come and open the gate. And the fact that our dogs were on our porch, on our property, when they were stolen by animal control was the reason the charges were dropped, because the state didn't have a case. It was politically motivated attack.
I thought it was a civil action.
The state prosecutes civilly. You're a prosecutor and you represent the state, and you're in the General Sessions Court, correct?
If that's a civil thing?
You not prosecute civil matters?
No, sir, Mr. Parsons, I don't.
You don't?
Those are criminal actions.
I believe it's civil.
I defer to you, Mr. Parsons.
Does it carry jail time to have animals get out?
Yes, it does.
Okay, I was told it was a civil matter. It was just a fine.
This unusual circumstance of your wolf hybrids getting out is not unusual at all, and it will continue to be a problem. You either are unwilling or unable to address it. Isn't that true?
Not at all. I think we've sat here and discussed that over the course of 12 years now, our dogs have gotten out 3 times. And the fact is that we've made provisions to correct the problem, and putting up this additional fencing, if they do get out of the 6-foot fencing by opening a gate or squeezing through or whatever, that they will be contained in there. But the fact is, what's being missed here is that these are not aggressive animals. People attacking our animals out of hate towards me is the reality.
Mr. Parsons.
That's why we're looking at moving. It's not an issue of the dogs getting out. It's an issue of people attacking my family because they just don't like me because I'm not part of this old boy's system and I ran for office. The fact that the defendants or the state's even witness said that he was mad at me and that he supported the other candidate. And at this scene, he even said, you should have kept your dogs in. And he wasn't in fear. He was on a hunt to kill my dog. He knew they were my dogs.
And this is reality according to you?
No, it's testimony by your witness.
That's all.
His own write-up.
Mr. Parsons, just briefly to follow up. As to the mental health issue, have you been diagnosed by any doctor or psychologist with a mental health condition?
No, sir.
Okay, how long would it take you to construct this fence that you feel will contain the dogs fully?
Not knowing the weather conditions, it's hard to say. Probably 2 to 3 months, given the current climate, the temperatures and weather in the wintertime.
Is it fair to say that that all of your appearances in the courtroom, whether they be civil or criminal, have had to do with your dogs getting loose?
One could say that, but I would say the state, the government coming on my property, stealing 3 of my dogs, when my dogs are on my property and falsely charging me, was an attack on me personally.
However the case has turned out in the end in the circumstances, would you agree with me that what gave rise to the incident, or at least a necessary factor, was the dogs getting out of the enclosure?
I think that was the excuse that was used to come after me, yes.
Okay, is it fair to say though that every incident that's caused you to be in court would not have happened but for the dogs getting out of the pen?
Those were contributing factors. But the fact that dogs on your property is not a crime still exists. And the fact that he had no right to cross the street and shoot my dog still exists. And so I'm taking every effort to make sure that my dogs aren't attacked anymore by keeping them, in the yard and on the property.
Okay. Let me ask the question this way. Assuming the fence is built that would contain the dogs in fully, given your history in the past, would this new enclosure prevent all of the past incidences, all of the circumstances of the past incidents from happening in the future? Would that avoid all of those different occurrences, whether they were civil or criminal?
First incident was where there was not a lock on the gate, so that was resolved by putting locks on the gate so people couldn't come up in the gate. And the second occurrence happened where we just had Brandy excited to see other dogs in the neighborhood, and she squeezed past the gate, so we put 2 latches on the gate so that she couldn't squeeze out. And so now, the dogs don't climb the fences, the dogs don't dig out of the fences. It's always been through a gate, but we're doing a larger enclosure to give them, that secondary fencing so that if they do happen to get, out somehow, they're, right there within, the yard. They're not going to go beyond the yard.
Okay, so the fence is taller and heavier.
Oh yeah, 7 foot. It's heavier material and, yeah.
In your opinion, it's going to keep your dogs in permanently?
Well, yeah, unless we're walking them.
And assuming the judge made it a condition of probation to complete this secondary fence, would you consider that a reasonable term of your probation, to say complete the fence in 90 days?
And we're talking about enough, the stack of fencing is 3 feet tall. We're talking about fencing off 1.5 acres, and doing it myself, it just takes some time. So it's not a situation where I can go out there in a week, put up this fence.
Okay, but if it were a term of your probation to say complete it within 90 days, would that be feasible?
Yeah, I think 3 months would be reasonable, and I would do everything possible, because I know January is certainly going to be a hard month. February at the beginning is not so good, but middle of February it's usually getting better to where you can do work outside. And
thank you, Mr. Parsons. No further briefing.
The defendant presented this same statement of how the events unfolded to the jury. The jury rejected the defendant's version and accredited the testimony of the victims, Mr. King and Mr. Laxton. The defendant still fails to appreciate the wrongfulness of his actions, where he held a loaded handgun to the head of the victims and threatened to kill them. The request for a diversion of the sentencing hearing will be denied. So we can proceed to sentencing. The state have anything else to present other than?
No, it's agreement submitted on the facts that came out of trial of the pre-sentence. And Mr. Parsons' testimony.
Yeah, we submit to the court that under 4035-113, the mitigating factors number 2, 3, 7, and 9 through 12 apply. That being that he had a strong provocation. Your Honor, of course, wasn't present at the trial, but it's my understanding of the facts, and based on what I've seen today, that clearly he acted under strong provocation. Any reports I know heard his share of animal cases, and they're emotional. I mean, they're always something we want to avoid either touching his attorneys because the emotions run so strong. So clearly he did act under strong provocation, and although the grounds, and as Your Honor just stated, the grounds did exist, at least in the jury's eyes, to justify self-defense, finding that self-defense is an appropriate defense, and they did find that he was properly effecting a citizen's arrest, that substantial grounds existed under subsection 3, getting to excuse or justify his conduct. And Your Honor, under subsection 9, I think it's not disputed, at least that he assisted the authorities, and at least he felt also that under the circumstances that he was affecting his own citizen's arrest, so of course he was cooperating with the authorities that they can in order to turn over all of the appropriate evidence and so forth that he received. And that also applies for subsection 10, assisting with property. And Your Honor, these are unusual circumstances. I mean, whether his dogs have gotten out the past or not, to see your dog shot in front of your face and have bullets, whizzing at your wife or in the direction of your wife, those are unusual, and that's not something that I've heard of. It's kind of bizarre. And Your Honor, we think that fits squarely within subsection 11, where it says that he committed the offense under circumstances where it's unlikely to happen again. He stated to the court that he would build this secondary fence, and he's already obtained material, so that's something we think will avoid this in the future. And Your Honor, it appears that through, I'm not political myself, but from what I understand, at least from this part of the testimony today, and what little I've seen in the record, that over the course of his life, the only things that have drug him into court are incidents with these dogs getting out, whether he's socked some guy in the nose or whether he's been sued or sued someone else over the dogs. It appears that, I know this is not necessarily the words that Mr. Parsons has used on the stand, but it appears, looking at it, that but for the dogs getting out, that Mr. Parsons would not have ever seen the inside of a courtroom. And we submit to Your Honor that with the completion of the secondary fence, that's an incident that's not likely to happen again. We ask that Your Honor show him mercy and sentencing and find that these mitigating factors apply.
I don't think these are unusual circumstances at all to prove that. It's unusual if you have the details about bullets whizzing past his ears and the direction of his wife, but I don't think that's borne out by the facts, and it's not supported by the jury's verdict. It's not an unusual circumstance if these hybrids get out. They've been getting out for 6 years. It's resulted in, according to Mr. Parsons, 3 of them being killed, which I guess would be 2 in addition to the hybrid that was killed in this instance. It's led to his punching neighbors in the nose or breaking their nose. There's nothing unusual about it at all. I don't think Mr. Parsons has been saying he'd take care of the problem by his testimony for 6 years. I can't imagine the wall that would be necessary to keep this from happening again. As far as his amenability to probation, I think that it's important And Your Honor has heard Mr. Parsons testify on numerous occasions to appreciate what his version of reality is, as far as his representation of attorneys, as far as his belief that everybody that has lived here from birth or from the last 20 years is against him, that there's some conspiracy, that the district attorney's office is conspiring against him, that officers are conspiring against him, that his attorneys are assaulting him, that Your Honor is conspiring against him, that assistant district attorneys are conspiring against him. His view of the law, of what's civil, of what's criminal, of who determines the law, all of it goes to show that he is a man out of touch with reality, who will not be amenable to any terms of probation unless he passes on their reasonableness. And if Mr. Parsons is the arbiter of what is reasonable, I submit that he's going to be manipulative. He's going to assert his control over things, just as he has or attempted to have over this system. And my prediction is he's not amenable to probation. It won't work.
Is anything else you want to
Present with regard to sentencing. While there's been a lot of focus on the hybrids, the court feels like the focus should be on the actions of Mr. Parsons in his confrontation with the neighbors. The jury accredited the testimony of the victims. The jury also heard a recording of the actual incident itself, and the jury has rejected the version that Mr. Parsons presented to the jury, which is the same as he presented here today. The court has considered the evidence received at trial, the evidence received today, the pre-sentence report, the principles of sentencing and arguments as to the sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the defendant on the mitigating factors, the statement that the defendant made in his own behalf, and the need to impose the sentence to reflect the seriousness of the offense, to promote respect for law, and to provide just punishment. The defendant is a standard offender. The court finds that there are no statutory mitigating factors that apply. The victims in this case were threatened with serious bodily injury. The defendant put a weapon to the head of the victims, told them he would kill them if they did not do as he demanded. There was provocation, according to the defendant's view, but the jury rejected that view. The defendant acted out of anger. The jury heard the actual tape recording of the incident itself. The defendant acted with the belief he could do whatever he wanted. The jury accredited the testimony of the victims that the wolf was charging and that Mr. Laxton was justified in his actions. Nick King had done nothing toward the defendant. He was working and minding his own business, yet Mr. Parsons placed a gun on him, threatened him, and continues to express that everyone else is in the wrong and that he acted appropriately. Despite what the defendant alleges, there are not substantial grounds in this court's opinion to excuse or justify his conduct. The court finds it's a proper case to sentence the defendant, however, to the presumptive or minimum sentence, and the court sentences the defendant to 3 years as a standard offender in count 3. He'll be given credit of time served in September of 07, July of 08, June of 09, and from November 23rd to today. He's sentenced to 3 years in count 4 as a standard offender, to 1 year as a standard offender in count 5, and 2 11 months and 29 days in counts 6 and 7 for the misdemeanor offenses of theft. The court finds from the evidence that the defendant is a dangerous offender. His behavior indicates little or no regard for human life. He had no hesitation about committing a crime in which the risk to human life was high. He accosted his neighbors with a loaded weapon, threatening to kill them if they didn't do as he demanded. He yelled them under gun or threat a gun while he took their property. And the court finds that consecutive sentencing is reasonably related to the severity of the offenses committed, that it serves the need to avoid deprecating the seriousness of these offenses from the actions of the defendant, serves to protect society from further criminal acts by the defendant who resorted to aggravated criminal conduct, and are generally congruent with the principles of sentencing. The consecutive sentences are justly deserved in relation to the seriousness of the offenses and no greater than the deserved for the offenses committed. So the court sentences the defendant to 3 years as a standard offender in count 3. Count 4 will be consecutive. Count 5 will be consecutive for an effective sentence of 7 years. The misdemeanor sentences will run concurrent with the first 3-year sentence. The court finds that alternate sentencing is not appropriate. In this case, the offenses involved a handgun. The defendant is not an eligible offender. He was convicted of offenses involving crimes against the person, violent offenses, and offenses in which the use or possession of a weapon was involved. And therefore, under TCA 4036-106 is not an eligible candidate for alternate sentencing. The court further doesn't feel it's a proper case for probation, and that confinement is necessary to protect society and avoid deprecating the seriousness of these offenses. The court would ask Mr. Witherington to represent the defendant on appeal if he desires to appeal his conviction or sentence. The motion for new trial needs to be filed within 30 days. The counsel filed a motion for bond to be reinstated, and the defendant filed pro se a motion for bond to be reinstated pending appeal. Bond was revoked after the verdict pursuant to TCA 40-11-113 and TCA 40-35-116. The constitutional right to bail is extinguished upon conviction, and a convicted person is not entitled to bail as a matter of right pending appeal. The right to bond is subordinate to the public peace and well-being of society, and the court believes that the defendant poses a threat to other persons in the community. And the court declines the request to reinstate bond, remain revoked pending appeal. Is there anything else we need to cover today?
No.
Stand in recess for a 10-minute break.